Okay, well, welcome everybody to today's webinar sponsored by the City of Raleigh's Fair Housing Hearing Board and Legal Aid of North Carolina. My name is Jack Holtzman. I'm one of the co-directors of the Fair Housing Project of Legal Aid of North Carolina. And we have an excellent webinar today, very relevant. Today's webinar entitled, Where Do We Go From Here? Understanding the Expiring Eviction Moratorium. We'll discuss what the existing moratorium is, what it means, how it will affect tenants who may be experiencing evictions, and how what you and other tenants can do to use the protections that are available in the existing moratorium. Today's facilitator is Tolu Adewale. Tolu is a staff attorney, he's an attorney and the assistant clinical professor at Campbell Law School in Raleigh, where he helps supervise the school's Blanchard Community Law Clinic. So now I'm going to just turn it over to Tolu, who can introduce the panelists. Tolu?
Good evening, everyone. So our initial panelists discussing the legal issues of the moratorium will be Mr. Jesse McCoy. Jesse is the James Scott Farron Lecturing Fellow and Supervising Attorney for the Duke Law Civil Justice Clinic. And also Ms. Sarah Dixon, who is a supervising attorney in the Raleigh office of Legal Aid of North Carolina. Both of them have extensive experience litigating eviction defense, tenant side eviction defense. So these are two of the best people we could have gotten to talk about this subject. So without any further ado, I'm just going to go ahead and jump right in. I've got my pen and paper out because I'm going to be taking notes to refresh my own memory on this stuff. So to start off, there's a lot of turmoil and changing information and a lot of stress and fear around housing. People are getting kicked out. People are worried they might be kicked out, but there are some protections available to try to prevent that. So let's actually start by making sure we're all using the same terms and talk about the eviction process. So first, in the eviction process, if someone is undocumented, do they have the same rights in court? Can they apply for the rental assistance programs or the free legal help that we're going to talk about throughout this program?
So I can start that off. First off, thank you for having me. Someone who is undocumented is entitled to the same rights in court as anyone else who is going through an eviction. The only difference is there are some legal programs that may not necessarily be able to provide legal representation services. So for instance, Legal Aid of North Carolina is not always able to provide legal representation. However, it's really a county specific thing. So for instance, I'm in Durham County, and even though our local legal aid office can't provide legal assistance, we can as the Duke Civil Justice Clinic. So I would just encourage people, if you are in that position, to contact 211 and find out what the resources are that are in your respective area.
Thank you. Okay, so Sarah, could you tell us in a nutshell what the eviction moratorium is and how long it's going to last? We'll come back and talk more about the details later. But if Sarah, if you could touch on that, and then right after that, Jesse, could you follow that up with an overview of the eviction process?
Sure. So good evening, everyone. The eviction moratorium that we're going to speak in detail about this evening, it exists pursuant to the Centers for Disease Control order, the first one of which was issued in September of 2020. What that order did was to stop court evictions of tenants due to the COVID-19 pandemic, and that prohibits evictions for non-payment of rent. So tenants who had some reduction in household income and were unable to make their rental payments, the CDC eviction moratorium is meant to keep those folks in their homes and prevent their eviction for the term of the order. And it's recently been extended, or rather a new moratorium was issued on August 3rd for 60 days through October 3rd of this year, in a nutshell.
Thank you. Okay, so Jesse, yeah, what is the eviction process that the moratorium is meant to stop?
So ordinarily, if there were no moratorium, we would have one of the fastest eviction processes in the United States. I think we annually are tied with Virginia as far as how fast we move. But just so people know, the first step in any eviction process is that the landlord has to provide you what's called a complaint for summary ejectment. And once you receive that complaint, 7 to 10 days from the date that you receive that complaint, there's going to be a hearing before a magistrate judge in small claims court in the county where you're located. At that hearing, there's going to be a responsibility on the part of the landlord to prove the allegations listed in the complaint. And if they are successful in doing so, there will be a judgment entered on that same day for that case. Once that judgment is entered, there is a 10-day window for an appeal period. And what that means is if you want to challenge the judgment, you have 10 days to appeal the case to district court. You also will need to pay what they call a rent bond in order to secure your ability to remain in the unit while you are appealing it to district court. If you do not appeal within that 10-day period, then on the 11th day after the judgment, the landlord can apply for what's called a writ. And once they get the writ, they're going to basically take that over to the sheriff's department, and the sheriff is going to ride out within 5 business days to let you know they're coming to padlock. And once they come to padlock, essentially that's game over. Now, there are some additional statutes about how many days, about 7 days that the landlord has to store your items after the padlocking. But for the most part, for most people, once that writ is executed, that's the end of the game.
Okay, so let's go through that a bit, and I've got a few follow-up questions. So the landlord has to give the tenant some legal paperwork called a complaint for summary ejectment. Now, what if the landlord just gives me something else in writing, or just comes up to me and says that they want me out? What if they don't actually give me the legal paperwork?
That's a great question. We can want what we want. I want $1 million. Doesn't mean it's going to happen. In North Carolina, you have to go through the summary ejectment process. If a landlord forcibly removes you from a property without going through the summary ejectment process, that is called an illegal eviction, and they can be sued for that. Also, I want to make sure people know and are abundantly clear that a landlord saying, I want you out, even if he's crying and huffing and puffing, a landlord saying that does not confer upon you a duty to immediately move out. So if you do immediately move out, you're actually giving the landlord what they want without them going through the proper steps. I would encourage everybody to stay put and see that process through.
Okay. Okay, so if the landlord does things right, they give me a complaint for summary ejectment, and then there's a hearing. So Sarah, you're in Wake County Small Claims Court for housing cases almost every week, if not every week at this point. Could you tell us a bit about how that works? What's going to happen when someone walks in for their summary ejectment hearing in Wake County Small Claims Court?
So in Wake County Small Claims Court, that court is held on the 3rd floor of the Wake County Courthouse. There are 2, sometimes 3 courtrooms that are used for eviction court. They have court at 9:30 in the morning and 1:30 in the afternoon. And so when a tenant receives a complaint and a summons, that summons is going to tell them what day and time their court hearing is at in small claims court. And so they'll go to the third floor of the Wake County Courthouse, and there will be lists of cases posted outside of each of the courtrooms, and the tenant can check those lists for their name to determine which courtroom their case is assigned for the day. When the judge comes into the courtroom, they'll call all of the cases that are scheduled to be heard that day and ask that if you hear your name called, you let the judge know that you're there. And so that is how Wake County handles kind of how they assign courtrooms and how tenants can find out where they need to be. And then typically the judge will go through the list of cases, calling each one up one at a time to first hear from the plaintiff in the case or the landlord, if it's a summary ejectment, to explain to the judge what brings them to court that day, what the reason for the eviction is. The landlord has the opportunity to offer any evidence and explain their case to the judge. Then they turn to the defendant, tenant, who can also explain their side of things, raise any defenses they may believe they have to the eviction, or dispute what any of the landlord's evidence was. At the conclusion of the hearing, the judge most often will announce a decision in open court and let everyone know what their decision is. Sometimes the judges can take some additional time to make a decision, and then the final decision is mailed to the parties at a later date.
Okay, so during the hearing, the landlord is supposed to prove their case, and then the tenant gets the chance to make their own case. And then the judge will issue a judgment. So, Jesse, could you I'm sorry, Sarah, could you recap again that appeals process and the rent bond? How does that work in Wake County?
So in Wake County, just like in every county in North Carolina, you have 10 days to file an appeal of a judgment if one is entered against you in small claims court. And so this includes eviction cases. You have 10 days to appeal that decision. And that is 10 calendar days, so it includes weekends and holidays. If the 10th day ends on a weekend or holiday, then you have until the next business day to file your appeal. You can, as Jesse explained, that if you want to stay in the property, in the house or apartment while your case is on appeal, then you are required to pay your rent to the clerk's office. If your case is for non-payment of rent, typically you may be required to pay a prorated amount of rent to the clerk's office at the time that you file your appeal. That would be the rent due from the day you were in court until when rent is next due. And then each month, if you intend to stay in the home while your case is on appeal, you'll have to make your rent payment to the clerk's office at the courthouse.
Thank you. So what are some of the common defenses? We're getting to the moratorium, but what are the other types of common defenses that tenants might be able to use to defend themselves?
So there are several, and it really depends on how the landlord has written this thing up on the complaint. So the first thing is, I want tenants to understand that when landlords come to court, about 85% of them are going to be represented by counsel. And it does create somewhat of a power dynamic because tenants largely are not represented by counsel. But the landlord still has to be able to prove their case. So if the case basis is failure to pay rent, then the landlord needs to be able to establish that the rent was unpaid. And there are a lot of different ways they can do that. One is providing a copy of the most up-to-date ledger to show that there is a running balance, and providing the lease to show that you do in fact rent that unit, and that there is a monthly rental balance or weekly rental balance, depending on the frequency of payments and how it's set up in the lease. If they are successful at proving that, there are still some defenses that may go against what they're claiming. So classic example has to do with habitability. If you have documented complaints and code report violations from the county inspector that date back to before this action was even filed, then there's a possibility for something that's called a rent abatement. And a rent abatement, all it is a discount on the value of rent. You're saying to the court that the value of this rent that I'm being charged in the lease is not commensurate with the habitability of the property. And if the magistrate believes you, if you have pictures, if you can show leaks, you can show pest control issues or structural integrity issues, the magistrate can actually reduce the amount of rent that's owed in a judgment. And if that amount of rent takes over what the landlord is claiming as a deficit, then there's a possibility that the case can be dismissed.
Okay, so worst case scenario. Actually, we already talked about what happens if someone loses. The appeals process that has to be started within 10 days, rent bond, and the opportunity for a new trial in district court. So I'll move on, but before that, could the two of you talk a bit more about your organizations and the legal assistance that is available free of charge?
Sure. So Legal Aid of North Carolina is a statewide nonprofit law firm. We provide free legal services to low-income individuals in a variety of legal issues, legal areas. That includes housing, eviction defense, domestic violence, protective order matters, unemployment benefits, Social Security benefits, other public benefits, and a variety of other kind of civil legal issues. So we don't handle any traffic matters or criminal matters. And so we have a helpline for folks to call to apply for legal aid assistance. We want to make that information available this evening to folks. That way they know how they can get in contact with legal aid if they do have any of the legal issues we'll be discussing later tonight. But we have a central call center where folks can call in, explain what their legal issue is, speak with an attorney, and get some advice at a minimum. Their case could then be transferred to any one of our field offices across the state for direct representation in court.
And the Duke Civil Justice Clinic is actually a law school class for advanced level law students who are seeking to learn more about civil litigation. So the cases are handled by students who are working under the supervision of both myself or our clinic director, Charles Holton. And we actually are involved in a number of different cases under that civil litigation umbrella. When it comes to evictions, we are also partnered with Legal Aid of North Carolina's Durham office, as well as Durham County Department of Social Services for what's known as the Eviction Diversion Program. But our eviction defense services only run within Durham County. Unfortunately, now we do handle occasionally some cases that involve habitability concerns, particularly cases that involve discretion of public housing. And we handle some of those outside of the county limits. But we also provide some assistance for people who are lower tiered healthcare workers who have their names posted on the healthcare registry following allegations of neglect, abuse, or misappropriation of patients' items. And we help them petition the Office of Administrative Hearings and fight those cases in order to see if we can get their names removed. So we do a wide array of things, and we also co-counsel with Legal Aid on a bunch of different cases as well. So if you have anyone who's having issues in Durham County, please feel free to reach out.
Okay, so we've talked about what the eviction process looks like and what rights the tenant has. But actually, before we move on to talk about the moratorium in more detail, I see some questions here in the Q&A that actually tie into what we've already talked about. So I'll go ahead and get to those. And I'll open this up to either of you, whoever wants to respond. But what happens if the renter does not go to small claims court? do they have to go to the hearing, and what happens if they don't?
So just to let you all know, if you get court papers, particularly in the eviction case, you're going to want to go to court. And the reason being is that if you are not there, you cannot put on a defense. And if you can't put on defense, then there's going to be a judgment entered that's solely going to be based on what the landlord has presented. That information oftentimes is wrong. So landlords have historically used ledgers that are not up to date or inaccurate. And now you may have a judgment against you for an amount that is not accurate. So I would encourage everybody to go to the hearing. Right now, I think there's been a little bit more leeway because of the moratorium, which we'll talk about in a second. But again, if you're not there to communicate the fact that you've done a declaration form and sought the protections of the moratorium, then nobody knows that you did. And the landlord it can't be relied upon to present your case.
And the next question is, are there any types of protections that are protections or defenses that could be available to a renter who has disabilities, if those disabilities tie into their inability to pay rent?
Yeah, sometimes, and it depends. Tenants, the Fair Housing Act protects tenants with disabilities and requires that landlords make certain accommodations for folks who may have a disability that impacts their ability to perform under the lease. We've had some success changing rent due dates for tenants who receive disability income on a certain day of the month, which makes it difficult to make timely rent payments unless they are able to get ahead on their rent payments to pay those in advance. There are other accommodations that could be available to tenants to help them to comply with their lease. And landlords do have an obligation to offer accommodations to tenants that are reasonable. And that is reasonable standard is open to interpretation. That usually is a case-by-case basis that you would want some legal advice on determining what is and is not a reasonable request to make of your landlord. But it's something that folks should be aware of so that they can seek help if they feel like they are entitled to an accommodation that their landlord is unwilling to give them.
Okay, so moving on from tenants' possible defenses like reasonable accommodation or habitability, or hey, I actually did pay my rent, and the right to appeal, let's now finally get to the moratorium. So, and here I'm going to kind of back off of my facilitator duties and really just leave it open to either or both of you for each question. So first, who is covered by the moratorium?
To be covered by the moratorium?
Yeah, who is covered by it?
Sure. So to be covered, tenants have to sign a written declaration and deliver that declaration to their landlords. All tenants, tenants can be covered if they are renting a residential unit. So an apartment, a house, anywhere where they live, and that's their primary residence. The declaration, it's helpful to, let me pull it up. The declaration is a form that's available online from the CDC's website. And we'll make sure we get a link to the CDC declaration form. To qualify, tenants must first qualify based on their income. Either they have received a stimulus check in 2020 or 2021, an economic impact payment, or their income was so low they were not required to report any income to the IRS in 2020. If they receive certain public benefits, including SNAP, TANF, SSI, or SSDI, or if in 2020 or 2021, they either earned or expect to earn this year less than $99,000 as an individual, or less than $198,000 as a couple. So that is the first level of qualification, whether the tenant qualifies based on their income. And then the second step is determining whether the reason that the tenant cannot make their full rent payment is a qualifying reason, which can include their household income has gone down, meaning someone else in the home who usually contributes is not able to do so. They've been laid off from work, or their work hours have been reduced, or wages have been cut, or they have extraordinary out-of-pocket medical expenses. And that has a very specific definition. It has to be over 7.5% or more of your adjusted gross income for the year. So that is really an extraordinary kind of percentage of your income. And so if a tenant qualifies based on their current income level, and also in the reasoning behind why they are unable to make their rent payment, then they would be protected by the eviction moratorium. And as I stated, signing a declaration and delivering it to your landlord is how you perfect the protection. And when you sign the declaration, you're certifying that you understand, or you're certifying that your income level qualifies for the reasons explained on the declaration. You have done your best to make timely partial rental payments, and you've also applied for government rent assistance, which we're going to talk about. That you live in a U.S. county that is experiencing a substantial or high rate of community transmission of COVID-19. This is new for this newest moratorium. It only applies if the county you live in is experiencing that substantial or high rate of COVID transmission. And so what we have done is we are constantly monitoring the rates of transmission in Wake County. It has remained high pretty much since the new moratorium issued on August 3rd. The moratorium will remain in place in Wake County until the county is below substantial transmission rates for at least 14 consecutive days. So that can be kind of confusing. We use the CDC's COVID data tracker to check on any given day what the transmission rates of COVID-19 are in our county. And it's unfortunate to see that our transmission levels have been so high since at least October 3rd. And there's no indication that they'll be going below substantial transmission in the near future. We can't see the future, but so long as COVID is transmitting at that substantial or high level in the county, then this moratorium applies. Because the real policy behind the moratorium is to keep people from being evicted from their homes during the pandemic when rates of transmission are so high. So that moves into the next part of the certification on the declaration, that if evicted, the tenant would have no other alternate housing. They would probably become homeless or have to go to a homeless shelter or move into close quarters to live with others. And they also have to certify that they understand that they're still responsible for their rent and any fees that may accrue during the moratorium, that they can still be evicted for other reasons other than non-payment of rent, that if they don't reach an agreement with their landlord, they could still be evicted for non-payment of rent after the end of the moratorium, and that they still have to follow all the terms of their lease. So it's a 2-page document that should be reviewed closely by tenants to determine if it applies to them. This is something that Legal Aid helps folks with to decide, does the CDC declaration apply to someone? If there are any questions about that, we have staff available to advise tenants about that. And like I said, the signing of that declaration and delivering it to your landlord is what then qualifies the tenant for protection.
If I could just add on that, I think that was a great explanation. The document is signed and it's under a penalty of perjury. The landlords do have the ability to challenge the things that you're signing on that document. So it's always important, if you do have your things like your W-2 or 1099 or whatever, just to have that in a file somewhere in case the landlord does decide that they want to challenge you on it. I have yet to see landlords do it en masse, but it's always a possibility. The other thing that I want to say is, so many people in the community don't realize that this moratorium is not automatically applicable. You have to do the declaration form, and you have to provide it to your landlord. If you do not do that, there are people who are being evicted right now because they haven't done the declaration form. So definitely take a look at it, see if you qualify, and if you do, take full advantage.
Okay, so I just want to go through and kind of summarize and make sure I understand those requirements. It's going to take, like Sarah said, close reading, and like Jesse said, as much documentation as you can find to back it up. But from what I'm hearing, it sounds like there are basically 3 categories of requirements. That you're a qualifying person, that you've got a qualifying reason, and that you live in a qualified county. And a qualified person, that is based on their income level, that they received one of the economic impact payments, or that their income level was not high enough in 2020, and so that they didn't have to report their taxes to the IRS, or if they earned below, was that 90,000, Sarah?
99.
99,000. If an individual earned below $99,000 in 2020, or if they will earn less than 99,000 in 2021. And what was that rate for couples?
190.
190,000.
198.
198,000. And so that's those are the people who qualify. The reasons that qualify are if someone experienced a COVID-related loss of their job, or a reduction in their hours, or COVID-related loss of income, and if they had a very high percentage, an extraordinary amount of out-of-pocket medical expenses. And does that have to be related specifically to COVID, or any out-of-pocket medical expenses?
It does not. So, and actually the reduction in income does not need to be COVID related either. You are certifying that your household income has gone down substantially. You've been laid off from work, your work hours or wages have been cut, or you've had extraordinary out-of-pocket medical expenses. Jesse, correct me if I'm wrong, but my understanding in reading the order and the plain language of the declaration is not that to be protected by the moratorium, you need to have a COVID-related reduction in income or medical expense. However, it does become important when you're applying for rent assistance, because a lot of our rent assistance programs require that COVID impact. There are some that do not require a COVID-related reduction in income, but that's an important distinction to be made. That tenants who are just unable to pay their rent for one of these qualifying reasons would be protected by the moratorium.
Okay. Okay, and then the last general type of qualification is that the person live in a qualified county, and right now Wake has been, and unfortunately probably will be for at least a little while longer. And also that the person would likely to, could you say that again, Sarah, that they're likely to become homeless or have to live with family or a few other things?
Yeah, so to be eligible, to be eligible for the moratorium, if the tenant is evicted, they have no other alternate home. They have nowhere that they can go where they could live. So they would either become homeless, have to go to a homeless shelter, or be forced to move in with others who live in close quarters, right? So most of us, we may have somewhere we could go moving in with family and things like that. But the idea is that then the commingling of households presents a risk of further COVID-19 transmission. And this moratorium really is focused on preventing transmission of COVID-19. And so for folks need to go into other crowded settings if they were evicted, that's what the moratorium is intended to prevent.
Okay, so besides this CDC moratorium, are there other kinds of moratoriums still in place?
So at this point, at least in North Carolina, the answer to that would be no. We've had a CDC moratorium. Well, let me back up. We started off with a CARES Act, but the CARES Act only protected people who were receiving a federal subsidy or who were living in places that had a federally backed mortgage. That ran from February of last year until the end of July of last year. Since that time, the CDC imposed a much broader eviction moratorium that ran from August 8th of last year throughout. We also had the benefit at that time of a state moratorium that imposed additional protections for tenants and forced landlords to have to take a couple additional steps. That has since gone away. So the CDC moratorium in its broadest form ended at the end of July in this year. And now what we have is the CDC moratorium that is limited to higher substantial COVID transmission rates. The governor's moratorium is gone. The North Carolina moratorium is now gone, which means that before it, under the state of North Carolina moratorium, the landlord had the responsibility of providing you with the declaration form. And if they didn't do that, they couldn't move forward with an eviction. At this point, they no longer have that obligation. So that's why we're encouraging people, if you don't have it already or you haven't seen it, to definitely go ahead and find that CDC declaration form, because it will be your responsibility to present.
Okay, so I think by my count, that's two major differences between the old CDC moratorium. The first one was that the first major difference was that the renter has to declare that they would have nowhere else to go, as Sarah was just talking about. And the other major difference I picked up on was that, as you said, Jesse, the landlord no longer has to tell the renter about the declaration. The renter just has to learn about that for themselves if the landlord doesn't tell them.
Right. That's the difference between the state moratorium versus the CDC. So CDC,
okay.
It was always on the tenant to have to do the declaration form. And in an initial iteration, it was not just the tenant, but every member of the household had to do it. At this point, we've adopted that as long as one person is able to do it, you're covered. But North Carolina made it such that landlords were responsible for providing that declaration form to tenants, which provided a little bit more protection than what the CDC order does.
Okay, so that leads kind of to the next question. If I gave my landlord a declaration under the old moratorium, does that still count, or do I have to give them a new one?
So I don't know if this is a county specific question, but it's supposed to still count. In Durham County, it definitely still counts. The whole concept is that you've just been seeking the protections of the order. So assuming that you are still qualifying and you are still seeking those protections, then it should still carry over.
And I agree. We're seeing the same thing in Wake County. Even though the prior declarations don't have the certification regarding the rate of transmission in the county being substantial or high, that's still going to be a requirement. So even though older declarations may not include that in there, I think it's implied. But yeah, so long as a declaration has been delivered, those tenants should continue to be protected.
Okay, so if the moratorium covers me, and if I give it to my landlord, do I still have to pay rent?
Yes, the one thing that the CDC moratorium does not do is alleviate you of any rental responsibility or fees related to rent. So late fees, things like that, can still be assessed. And this is the concern that a lot of people have been on the front line trying to fight. Ultimately, the CDC moratorium, as it stands right now, is going to end on October the 3rd or whenever these COVID numbers, the COVID transmissions drop, right? So once you're below that higher substantial status, the moratorium goes away. Or if the Supreme Court says it goes away, right? So if any of those things happen, it goes away. And the landlord at that point is going to be able to move forward with an action to collect the total amount that's due, even if you haven't been able to pay rent for 6-7 months, because at this point, there's no other protection. So it's important for people to know, and this is where rental assistance programs come in. If you have a rental assistance program that's serving your area, or if you have put in an application with NC Hope, the whole point of that is to help people offset the deficits that they're owed, because many folks have already gotten gainful employment and they just haven't made enough to be able to cover that deficit. So the whole point of Hope is to try to get you caught up so you can take over and be sustainable moving forward. But it is important. The CDC declaration does not alleviate your duty to pay rent.
Exactly. And to add to that, you know, the declaration, you're certifying that you will make your best efforts to make at least partial payments to the extent you're able to during the term of the moratorium. And then you're also promising to apply for all government rent assistance that may be available. So not only are you still required to pay rent as you can, but then you have this additional requirement to go out and see and apply for assistance that could be available to you. Hope is a great way to find out what types of assistance are available in your particular county. We're going to talk later about specifically resources that are available for folks in Wake County, and how you can apply for that type of assistance so that you're in compliance with your CDC signed declaration.
Okay, so, and this is kind of a related question, but what should I do if I know that I will not be able to pay rent to my landlord for future rent?
So I think it depends. I know I hate to give the lawyer answer, but it depends. The first thing is, you know, there are different programs that serve different counties, and some of these programs are paying not just back rent, but future rents. So if you're in a county that has a program that will provide that, as long as you qualify, by all means, you need to take advantage. There's $47 billion of federal money that was put into these programs for the sole purpose of being able to stabilize people's housing so they don't get evicted. So there's no sense in not checking to see if you can qualify for some of it. The other thing I'll say is there are, people are in different situations. So there are some people who are saying, I won't be able to pay future rent because I've lost my job. But the problem with losing your job is until you get another one, those rental obligations are going to continue to accumulate. So every month under the protection of the moratorium, you're still going to have a higher and higher bill. And unfortunately, for some people, there's a point of no return where if you're not able to access rental assistance, then you're at some point, this is all going to end. And when the moratorium goes away, you're going to be subject to an eviction. So what I've been encouraging people to do who fall into that situation is to talk to the landlord and try to see what arrangements can be made to extend the time that you're there so that you can look for other places. And if you're able to look for other places and move somewhere else and hopefully don't have the burden of an eviction judgment on your record, it's going to be easier. And I say that because once that eviction judgment is lodged against you, that is going to impact not only the places where you're able to go, but the quality of the places that you're able to rent from, because then you become an eviction risk. So it's better to be proactive. Don't put your head in the sand and just pray it away. It's better to try to deal with it as best you can on the front end. But with so much money in these rental assistance programs, it is important that you exhaust the calls and applications for those programs, because their whole charge is to get money in the hands of Americans to prevent eviction.
Okay. So if I'm being evicted for a reason other than failure to pay rent, am I protected by the CDC moratorium if I fill out the declaration and deliver it to my landlord?
Unfortunately, no. The CDC order does permit evictions for reasons other than non-payment of rent. What we see in North Carolina, in North Carolina, there are 4 bases for eviction, basically. There is non-payment of rent, holding over after the initial term of your lease has expired, breaching the lease, or committing other certain criminal activity that is grounds for eviction. And so when tenants fail to pay rent, oftentimes we see the landlords make that selection on the complaint. They may also allege that the tenant has breached the lease by not paying the rent. Those are the 2 cases or claims that are types of cases that are covered by the moratorium because they are dealing specifically with non-payment of rent. If your landlord has some other reason in addition to non-payment of rent that could be grounds for eviction, that eviction could potentially still go forward, even though it's also a non-payment of rent eviction. We're also seeing more commonly landlords who are choosing not to renew leases and file evictions based on the tenant holding over after the end of their lease. Landlords will go into court and say, this isn't about rent. I just want my property back. And we are seeing courts in Wake County issue eviction orders for folks who were behind on their rent, delivered a CDC declaration to their landlord, but their landlord filed the eviction for another reason, saying that the lease period had ended. I don't know about what you're seeing in Durham, Jesse.
Very, very similar. So I want to emphasize what you brought up about the breach of lease. If the breach of lease is related to failure to pay rent, then that is just a back end way of trying to get around the order, and that's not going to fly. So you need to be able to present against that. The other thing I always like to remind people is this concept of retaliatory eviction, right? So if you have complained to the landlord about conditions in the unit, or if you have complained and you have provided a declaration form, or whatever the case may be, and the landlord decides now to change up what the basis of the eviction is going to be, the argument can be made that they're doing this in retaliation for what you've said. And if the magistrate sides with you in that argument, then you win the case and the complaint gets dismissed. So every landlord is different. They're not monolithic. Some are, most of them are accustomed at this point to the way that the moratorium work, and they will continue it out until the end of the moratorium. But you always have to be cognizant of what's going on. And this is why I would, again, encourage everyone, if you have a court date, to show up so you know what actually gets said to the magistrate.
Okay. I think that covers all of the questions about the moratorium that that we have gotten so far. We have a few questions in chat right now, so it looks like we'll be opening up the Q&A a bit early. But let me just take one last look through these questions here. Okay, I think the last one before I get to these chat questions will be, what if my landlord already filed a complaint? I've gotten the complaint and summons, but before the hearing, I fill out the declaration and I give it to my landlord. Could the declaration still protect me? Could the moratorium still protect me?
Yes. Yes, there's no requirement that the declaration be delivered to your landlord before they file an eviction case against you. And in most cases where we're involved, the declaration is delivered after the case has already been filed. And even on the morning of court, if a tenant delivers a declaration to their landlord, they are facing a non-payment of rent eviction. They can then request that eviction hearing be continued until after the moratorium ends. And that tenant is protected from eviction.
Okay, and I think I know the answer to this next question that just occurred to me, but I'll ask it anyway. I'll ask the experts. If I don't fill out the declaration, if the landlord gets a judgment against me in small claims court, but I appeal to district court, can I then fill out the declaration, deliver it to my landlord, and get a continuance, get that case postponed.
Yes.
Yes.
We've had folks to deliver declarations at any time before they are legally removed or evicted from their home. So what the moratorium does is it protects the tenant from being removed from the home. And so even if a tenant does not appeal, if that declaration is delivered to the landlord, then they should not take any action to remove the tenant from the home pursuant to that eviction order. Now, if that is the case with a tenant, they should absolutely seek legal advice because oftentimes landlords will seek to actually evict and remove tenants from the property, even if they've been given a declaration. And so they may need some additional assistance with enforcing that protection at that time. So as soon as you can, if you believe that the CDC moratorium applies to you, the sooner you can sign and deliver a declaration to your landlord, the better.
And in the scenario that Sarah was describing, if you have not appealed the judgment and it's already beyond the 10 days, the other thing I want you all to understand is the sheriff's department in every county operates a little bit differently, right? Mm-hmm. So the way that it's supposed to work is once anybody is notified of this declaration, it's supposed to halt all eviction processes. So that writ is still going to be held by the sheriff, but for now, it won't be able to be executed. Of course, there's been some pushback on that, and it becomes a very political issue as to who does the sheriff's department answer to. But at the end of the day, I just want people to know the declaration form is there for you to seek the protections of the order, and the order exists. So federal law is supposed to trump anything else that's out here. It's federal law as it stands right now until October the 3rd or until the COVID transmission numbers decrease. So we might as well take advantage of what's available.
Okay. So if my eviction is stopped because of the moratorium, if the moratorium is overturned or it just expires, that would just mean that the eviction can keep going from whatever stage it stopped, whether that was the small claims court hearing or the appeal, or even if it was with the sheriff and they have to wait to execute it. Would that be correct? That'd be correct. That would just it would just basically undo the effect of the moratorium.
Right. It's kind of a timeout. So the earlier that you do it, the better, because you would love to not have a writ at all and not have a judgment at all. But it's just a timeout post judgment. So it'll stop the ability of someone to get a writ or stop the ability of that writ to be executed. But once the moratorium protections go away, then we go back to business as usual.
Okay. And I think with that, I'm going to ask again about help finding legal services for people who have joined since we first talked about that. But if you could both just briefly say again what agencies you're with and the phone numbers or the websites where people can reach you. Sarah?
Sure. Legal Aid of North Carolina, you can visit our website to find out more about the services that we offer, and you can submit an online application there as well. We also have the contact information for our call center, which we call the helpline, where you can call in to ask questions about your case to determine if it's a case that we can give you some advice about. Our website is legalaidnc.org, and the helpline number is 866-219-5262.
Thank you. Jesse?
Duke Civil Justice Clinic. Again, we are a law school course that operates also in conjunction with Legal Aid of North Carolina's Durham office and our partners at the Durham Department of Social Services. We operate that as part of an eviction diversion program. What will happen normally is a resident of Durham County, excuse me, will contact DSS, excuse me, will contact DSS, and DSS will refer your case over to either the legal aid office or Duke Civil Justice Clinic if you don't end up qualifying for legal aid. You can also reach out to us directly, but I will say, we do have geographic restrictions when it comes to eviction cases, so we're going to be limited to Durham County. But you can reach out to me directly via email. That email address is McCoy, MCCOY, @law.duke.edu.
Okay. So with that, I'm going to get to the Q&A questions. We've got a handful so far, so if you have any, keep them coming. And some of these might recap things, but people ask them, I want to go ahead and recap the material because it's a lot, and I find it helpful to just go over it as many times as I can. So the first one is a new question. Does the moratorium cover long-term hotel guests?
So this is actually a hot topic legislatively. As it stands right now, I would argue yes. Now, this is probably something that if you're in this situation, you're going to want to reach out to legal aid and you're going to want to have counsel for. But I would argue yes. The hotels and motels have a different standard that they're under, and they would like to deem everyone to be innkeepers. In fact, there's a very controversial bill that was presented that would deem everybody, even long-term hotel stays, as an innkeeper relationship, because an innkeeper relationship is just a business transaction and there's no duty to even go through the process. But if you are in a long-term hotel and they expect that you're going to be paying rent with some degree of frequency, week to week, month to month, whatever the case may be, particularly given the fact that we have COVID going on and this moratorium is designed to stop the transmission of COVID through the eviction process, then I think the argument definitely can be made that you are a tenant under the eyes of North Carolina law. Now, again, you would definitely want to have an attorney who's going to be able to argue this for you because it's going to require some case law research that the average person doesn't have. But I would argue yes.
Yeah, so the CDC order says that guests and transient guests in hotels are not covered by the order, right? But we have people who live in hotels and motels as their primary residence. And so they don't have any other home. That is their home. They receive mail there. That's where they're preparing meals. They're living there. They're not getting usual hotel amenities. Their rent, like Jesse mentioned, is due differently. It's not by the night. It could be by the week. The amount of time that they've been there, they may not be considered a hotel guest. And so just because you're living in a hotel does not mean you're automatically not covered. It does take, though, looking at a case-by-case basis to see whether this is the primary residence of the tenant, that they're a tenant and not a guest. They're paying rent. They're not, paying a nightly room rate. And so that is a distinction that can be made.
So what I'm hearing is that under current law, the amount of time you've lived in the hotel is just one factor, but the real question, again, under current law, is if it's your primary residence. But definitely try to get help from legal aid or other free legal services to be ready with that legal research that the judges will want to see, and to really break down the factors of the specific case to show to the judge that I really am a long-term, this really is my primary residence.
Absolutely.
Okay. And I do see here a question: does the previous CDC order carry over to the new limited moratorium, or would a new form have to be submitted to a landlord in qualifying counties? I know that that was answered before, but I think this is certainly something that's worth repeating. So Sarah, if you could take that.
Sure, yeah. If a declaration has already been delivered to your landlord, you're not required to sign a new one. If you do want to sign a new declaration, the new form states that a tenant signing that declaration is protected from eviction until after October 3rd. And it does include that certification regarding the rate of transmission in the county where the tenant lives. And that form is available online through the CDC's website. It's posted online. So if you Google CDC declaration, you'll be able to follow a link to that form and download it. And we also have those forms available oftentimes at court. If we're in court, we make those forms available to folks to review. We have them available at our office. So we have staff who are able to kind of get those forms out to folks. And I think that whenever you apply for rent assistance, that's one of the first things that agencies are asking if the tenant has signed and delivered a CDC declaration. So those forms are being made available to tenants at a variety of places.
Okay. So going from there, and I was reading through the question, so you might have already just answered part of this, but how can renters show proof of having applied for government assistance or all of the assistance that they are eligible for? This particular person who's asking the question is concerned that most Department of Social Services aren't offering these services. Now, I'm not sure if they mean that they're not offering any kind of assistance, or if they mean that these programs are not offering any proof of application. I'm actually going to jump in with a bit of an answer. I'm a big fan of screenshots. Whenever I'm submitting any kind of important application, at the last stage or at every stage that I can, really, because I take screenshots because computers crash, internet connections die, and you don't know for sure if you'll get one of those automated confirmations. So screenshots can be one way. Any other tips from the two of you about how to show proof that I have applied for applications, that I have applied for assistance?
So I think this is also going to be very county specific. I'm not sure about Wake, but I know in Durham County, we actually have Department of Social Services representatives in the courthouse who have computers that can access their database to say if someone has filed an application or not. So as long as they can confirm that an application was filed, typically those cases are going to get continued. I would echo totally with taking screenshots, or at least keeping a copy for those people who are doing physical copies. Just run a copy for yourself and keep one to bring it. The only time that this really comes up would be if the landlord is trying to challenge the declaration that you've provided them with. And oftentimes, at least in my experience so far, there aren't a lot of landlords who are challenging it. So it's kind of flying under the radar. But it is good to have, and it is good to keep in the file just in case that challenge does come.
Absolutely. And in Wake County, if you submit an online application with Housewake, you're going to get an email confirmation about the submission of that application. I would also encourage folks just to document who you talked to. What number did you call? When did they say, that you would hear from somebody? Oftentimes, just being able to detail the efforts that you have made will be sufficient, especially with a lot of the other agencies that may not be providing direct documentation proof, like a receipt that you've applied. But a record of who was contacted and when is going to be really important just for tracking your own application, right? And following up and making sure that you've done everything you need for that application to be processed.
Okay. So, so if a renter is approved for rental assistance, but the landlord refuses to accept that payment, could there be any protections for the tenant based on that refusal? And again, I'm going to get ahead of you and say, because I still remember, it depends. And I know it's going to depend entirely on the facts of the specific case. But speaking in general, could a tenant have a defense based on that?
Well,
So, go ahead.
the landlord's refusal of rent assistance is not going to impact whether the moratorium covers a particular tenant. So I want to make that clear. The tenant is obligated under the moratorium to apply for the assistance and try to get the funding to cover their rent arrears. We are seeing landlords who don't want to accept the assistance. They would rather have the tenant be removed from the property rather than accept the rent assistance. So that is something we're seeing, but that does not impact the tenant being protected from eviction under the moratorium, which I think is the first point that we really want to make clear. And then Jesse, if you want to add anything to that about remedies that may be available if landlord rejects the rent assistance.
No, I was just going to echo what you're saying. So the strength of the rental assistance is kind of tied into the moratorium, right? What you noticed before is when there was a more broader moratorium, even with the state moratorium, and people started getting rental assistance, there was a lot more of an acceptance rate because we didn't know how long the moratorium was going to be here. But now the moratorium has been challenged in higher level courts. And there's a leaning, at least from the United States Supreme Court, that this moratorium may be deemed unconstitutional. So if that happens, the moratoriums all go away. Until that happens, then landlords right now largely haven't been receiving rents because even though there's an obligation that people make partial payments, most landlords in North Carolina refuse partial payments because they don't want to be deemed to have waived their ability to evict at a later point. So what that means is get the rental assistance and provide it. Now, on the landlord side, there are a lot of reasons, some very legitimate, as to why the landlords don't accept the rental assistance. One such reason is that many of these programs require a 60-day non-eviction period following the acceptance of the rent. So what that means is, even if the rental assistance program is only paying a deficit of 4 months and you go into a future month and don't pay the rent, well, it's barring them from being able to evict you in that future month and the one thereafter. So a lot of landlords are like, I'm not comfortable with that. If they're not comfortable with that, there's nothing that forces them to take the rental assistance. And unfortunately, that's when you have to have those tough decisions and conversations about what you're going to do next for a next step. But I'll also say, you never know with the moratoria what it's going to do. If there's going to be an extension, if we've got the Delta variant coming up and Lambda's on the heels of Delta. So if there is a belief that there's going to be an extension of the moratorium, then a lot of landlords will say, I'd rather err on the side of accepting what funding is coming down the pipe as opposed to waiting on theoretical money that I may or may not ever get. But it really depends. It's all on the strength of the moratorium. So right now, I would encourage people to try to get it. On top of that, because we know it's $47 billion, there's plenty of money available that's being siphoned through the 50 states for this purpose. So if you qualify, you should get it. You should try to give it to the landlord. You can't force them to accept it. But if they don't accept it, because the money is technically coming from a third party and not from the tenant, it becomes a little bit more difficult to use some of the traditional defenses that we will ordinarily be able to do as far as satisfaction and things like that to say the rent was paid because they are not obligated to take it.
Okay. And if I'm reading this Q&A window right, I think one of our other panelists from the Office in Equity Inclusion might have also wanted to jump in here, or maybe I'm reading it wrong. So I'm going to just pause for a second for any of the other panelists who might want to answer this to unmute themselves and turn on their video.
No need for that, Tolu. I was just saying that question had been answered.
Gotcha. Okay, thank you. Okay, so Jesse and Sarah, could you describe the difference between an eviction filing that is seeking possession and an eviction that is seeking money owed? And do these two types of filings or these two goals that the landlord is seeking, do they have to be done separately, or can the landlord do those two things together? And I'm gonna kick this to Sarah first.
Landlords can, they can sue separately for a rent balance or other damages that they may have incurred as a result of the tenancy. And they can sue for that separate from the actual possession of the property, which we call a possession only complaint. I think there may have been some thought that if landlords were seeking possession only, then perhaps the CDC moratorium would not apply to that case. But as long as the basis for their claim for possession is non-payment of rent, then the moratorium would apply. I think we see landlords more often making the business decision to not seek a money judgment, but rather pursue other means of collecting past due balances from tenants. And so they may seek possession only and no money when they go to court and just seek the eviction order. But they do have to specifically reserve the claims for the money that is owed if they file for eviction only or possession only. Does that make sense?
So could you go talk a bit more about what it means that they have to reserve that claim?
Well, I won't get too much into that specific detail. I think that for purposes of tenants who may be listening today, the landlord has to select a reason for why they are seeking an eviction and asking for an eviction order from the court. And if that reason is because rent has not been paid, then that case could be eligible for protection under the eviction moratorium, and that tenant could be protected from eviction. The landlord can include the amount of rent that is owed, or they could write on the complaint that they only want possession and they're reserving their claims. And so to explain what that means, that's what means that if they're reserving their claims, they may sue later or pursue other ways of collecting the past due rent, reporting that balance to collections, or trying to collect from the tenant at a later time.
Okay. And so got sort of a question about a related issue, foreclosure protections for homeowners. Since Sarah, I know that you do a lot in mortgage foreclosure defense. Are there any, could you just generally outline, first of all, are there still any COVID related protections for homeowners? Does this order cover homeowners or just renters?
The CDC eviction moratorium, the CDC order does not cover homeowners. This is an eviction moratorium for renters. So, however, there are other foreclosure moratoria, at least for certain federally backed home loans. And I believe that moratorium is in effect until the end of this month. Don't quote me on that. I'm not absolutely certain. But that is definitely something that legal aid can advise homeowners on. If they have questions about whether there's a foreclosure moratorium that applies to them, then they can contact legal aid for assistance. We are anticipating also mortgage assistance coming available for homeowners who may have fallen behind in their mortgage payments. And 211 is going to be a great way to find out information about those resources that could be available to people. And then also contacting legal aid. We try to connect applicants to what resources may be available to them.
Okay, that is actually a perfect transition to bring in our other panelist, Mr. Nick MacLeod. Mr. MacLeod brings more than 10 years of community and housing organizing experience to the North Carolina Housing Coalition, where he is the director of local organizing. And he's worked with tenant associations, faith institutions, immigrant rights groups, and community development corporations to build the Staten Island Housing Dignity Coalition. And for the past 2 years, he's been working on campaigns in North Carolina for Medicaid expansion and expanded economic opportunity.
Hello, good evening.
And
Thanks so much for that lovely introduction. Glad to be joining.
And so, sorry, I'm just checking through one more time. And so I'm sorry, my notes here aren't super clear, Mr. MacLeod. Can we field questions to you about resources that are available, or?
Yes, so I'm happy to answer some questions on resources that are available, although I'm sure Jesse and Sarah will also be able to help folks navigate that. My role is also to answer questions around any kind of advocacy questions. Are there ways that these programs can be strengthened, or if there are tenants that have questions about doing tenant organizing in their buildings, which is really my sort of area of expertise. Yeah, and I do have some good news actually to share, which is not a fun thing as I usually get to say. So in the second round of emergency rental assistance, the federal government required local rental assistance programs to provide direct to tenant assistance if landlords refuse to participate. So what that means is, while it's not the same legal protection as Jesse mentioned, that you have the 60 days of protected time after the rental assistance payment is paid out, it does mean that if a landlord is refusing, assuming that Housewake follows those recommendations, which I would think they will, then that would mean that tenants would be entitled to the direct to tenant assistance, which they can then use to pay in their current housing, or they can use to pay down security deposit and find alternate housing. So luckily, it doesn't quite answer the question of what legal rights do folks have if landlords refuse, but there should be a shift in the policy so that tenants have access to that rental assistance, those resources.
Fantastic. And so one of the questions that we got was whether there are any resources available to assist with back rent payments. I know Jesse at least hinted at that. And I think the answer to that will clearly be yes, but also check 211. It really is what it sounds like, just 211. Actually, I think it's 211 NC. I had not heard of it before getting into the rent assistance world, and I wasn't sure if that meant just dial it on the phone, but go online, 211 NC, or I'm seeing Nick nodding. So it sounds like you also can just dial it on the phone.
So probably the most direct way to get access to rental assistance would be if you have access to the internet, going online. One thing that is a little bit complicated about the shift into this most recent round of rental assistance is we had the HOPE program, which is the rental assistance program, was uniform across the state. That's no longer the case. So now there are distinct rental assistance programs in 12 counties, and then the remaining 88 counties are covered by the HOPE program. So Housewake is the rental assistance program for Wake. There's a Durham specific rental assistance program. For the sake of speed, if you can, I would recommend just going directly to the Housewake website, right? And there you'll find all the information to just apply. 211 is a really helpful resource. That is sort of a referral service catch-all. And so you'll go to them and then they'll help point you in the right direction. That being said, if you know what you need is, I gotta go talk to someone at Housewake, you can go ahead and just directly do that. There's a very helpful map on, if you just look, Google North Carolina HOPE program, and I can put it in the chat as well, a map where you can find your county. It'll tell you if it's a local program or the state program. Click on that, and then it'll bring you to the right page to apply for the relevant program for you.
Okay. Okay, so then we do have one or two questions here about activism. So I'll give this directly to Nick. Is there anything that community members can do collectively to encourage the governor to reinstate a protective order for renters, because this issue is having an enormous impact on people's mental wellness?
Yeah, absolutely. The short version of that answer is I would love to talk to you for hours about the answer to that. There are many different things you can do. I think there are many different local organizations that are working toward asking both the governor and then also more local government entities to be taking proactive steps to protect tenants against eviction. So I would just really encourage you to link up with an organization in whatever county you're in to start to engage with them, right? Because as you're saying, I think the collective is where the power is, right? One of us calling in the governor's office, important, doesn't super move the needle, right? Hundreds of people, thousands of people, you and as many of your neighbors as you can possibly move calling in, that's where things really start to shift. And so really encourage you to get involved in a local organizing group that is going to give you that infrastructure and support to be able to get to the scale where you have the power necessary to really move this. So yeah, absolutely. I don't have a sort of, I mean, you know, if you want, there are plenty of sort of like action items on our website, the North Carolina Housing Coalition, to send emails or call into the governor's office. And that is all great. And the sustained work on the ground is where the real fundamental shifts change. So I think that is really linking in with organizations in your community that are doing that organizing, and then go to them and ask, hey, are you paying attention to evictions? Do you care about this? I want to move forward on this. Will you support me to do that?
Just scrolling through to see, to make sure, to see if there are any other questions related to organizing and activism. But I think that, excuse me, I think that really covered a lot.
So if I may, briefly, one thing I do just want to share, right, I'm not a lawyer, and so I get to say more expansive things. I'm occasionally contemplating getting that as a face tattoo, but I've not done that yet. So one thing that's really important, right, is that we've heard a lot about where's the legal levers to protect yourself against eviction, and understanding that is really valuable. And I'll give a concrete story from tenant organizing that the Bull City Tenants Union is doing in Durham. They have been able to organize in buildings and fight back evictions that were not covered under the CDC eviction moratorium, right? We've had tenant leaders who had evictions brought against them for holdover cases, not a non-payment case, not covered under the eviction moratorium, but through really effective organizing, convinced the landlord to drop that case. And so just want to lift up, right, that thinking about the legal process is really, really critical and important. And also you can think about other access to power, about how are you going to be able to join with your neighbors and be able to exert that. And so I think if anyone had a takeaway where they're feeling like, oh, my situation, it doesn't quite fit under this thing, and that's really frustrating and hard, right? The good news is that with enough power, anything is possible. And so if you can gather enough of your neighbors and pull something together, really remarkable things are winnable. So I would just lift that up.
Okay. So I'm seeing a few questions here. Two questions about funds and resources to become a homeowner. And that's, of course, probably the only long-term solution to avoiding the possibility of eviction. And I know that the North Carolina Housing Finance Agency has a role in that. But I'm gonna first kick this to Sarah, because again, I know that's within an area that you've worked. Are there, and this is not a specifically COVID-related question, but are there any ongoing North Carolina programs that offer funds or loans for people to become homeowners, or even if it's just the NC, the North Carolina Housing Finance Association?
That's where I was going to direct folks. I don't have a ton of experience with folks who are seeking home ownership. But the North Carolina Housing Finance Agency absolutely is a great place to start. I think that also HUD has a list and a directory of housing counselors who may be available in your area. And those folks definitely have resources for home ownership readiness and good advice about really positioning yourself to be a homeowner and endeavor to find what resources may be available to you for that.
And I'm seeing another question about long-term hotel residents. How can evicted tenants get help getting out of the hotel environment? And feel free to jump in, but I think the answer to that again is going to be nc211.org. Again, really a tremendous amount of resources available. It is a lot to get through, and there will be a lot of paperwork, but really just a whole lot of funds that are available for people who qualify.
And in Wake County, they've tried to streamline the process for folks who are seeking assistance. So I want to speak specifically to our Wake County folks. Housewake.org is the place to go to submit your online application for rent assistance for Housewake. Telamon is administering that program. Oh, I see Lamont mentioned the City of Raleigh Homebuyer Program. So we may want to touch on that on the homebuyer question. But real quick, on the resources for folks who are living in hotels and want to get out of living in a hotel and hopefully find long-term stable housing. There's also in Wake County the Wake Access Hub, and this is another partnership of agencies in Wake County who can assist folks with securing a rental. There's financial assistance that comes along with that to help folks to put down a security deposit, and some rent assistance for a traditional, apartment. And they also offer some supports for helping to locate housing. And I know that Wake County has a lot of they recognize that that's a need for folks to find long-term affordable housing, and their agencies and networks of agencies that are able to help tenants who find themselves in that position. So the Wake Access Hub can be reached at 919-443-0096. Housewake, Telamon can also make referrals for that purpose, and you can find more. You can apply for Housewake at housewake.org.
Okay, and excuse me. With that, actually a reminder, and me finally making sense of my notes here. I'm also going to invite our other panelist, Mr. Lamont Taylor, with the City of Raleigh, to please go ahead and unmute himself and turn on your video. Thank you for being with us, Mr. Taylor. Sorry for that confusion. But if you could go ahead and just give us sort of an overview of the City of Raleigh assistance opportunities that are available.
Absolutely. And if I can get one of my colleagues, Travis or Demetrius, to actually share the screen. There is I'm going to start with Housewake COVID-19 Financial Assistance Program. And while we're waiting for that, and we can certainly send this out, I'll just give you the basics of the program. So the Housewake Financial Assistance Program provides rental assistance to households who are at or below 80% of the area's median income. To qualify for the program, the household must demonstrate a loss of income or a financial impact due to COVID. So there has to be some demonstration of that. And then there are also some proxies. If you're receiving other forms of federal assistance, there are some proxy opportunities as well to qualify. It basically has 3 components. It has direct financial assistance in the form of rental assistance, as well as utility assistance that can cover past due rent, as well as utility assistance starting with the beginning of the official date of the pandemic, which I believe is March 20th, and it's on the flyer. I'm actually not reading it, going from my memory right now. Second component is legal counsel for renters, provided free of charge to those households. And then the third intervention is relocation assistance. This assistance is available only to households at 50% or below area median income. So there is an income restriction there as well. The program does prioritize, while it does assist households up to 80% of area median income, there is a priority for households at lower incomes below 50%. So those households are prioritized, but it is first come, first serve with the priority for 50% or below. The website is available here, as well as the telephone number to call. And I'm just thinking of any other salient details that I might need to share. Again, it is rental assistance and utility. So that covers all of your utilities, including your City of Raleigh water bill if you live in the city limits of Raleigh or in a Wake County municipality that is provided water by the city. And again, it is actually up to 15 months of rental assistance. Our program really sort of caps it at 12, but there is flexibility to assist households up to 15 months. And again, it can go back to, it's actually April 2020. And then, so it can cover arrears, and then it can cover forward rent. The way the program works is the household basically is eligible for up to 3 months of assistance at a time. So there's sort of a housing assistance contract that covers a 90-day period, and recertification is required every 3 months of assistance. We have talked a lot about, or a lot of discussion around landlords not accepting the assistance. The program does allow flexibility to make direct payments to the tenant. City of Raleigh is and Wake County, and I'll pause here. This program is City of Raleigh and Wake County funded, partnering with Telemon. So we both received emergency rental assistance program funds from the U.S. Treasury, and we combined our funding to have one program. But in terms of landlord participation, the Treasury guidance does have a certain preference for landlord participation in the program. However, there is some flexibility if the landlord refuses to participate or just doesn't respond to inquiries from our contractor Telemon, that we are able to make direct assistance to the tenant. We are not currently, that provision of the flexibility is not currently in place. We are working on ways to mitigate the risk. Obviously, it's a little unsettling that somebody could get a check for back rent for $10,000, $12,000 and actually end up homeless and not pay their rent. So we are working jointly to figure out a solution to make it as flexible as possible, but also mitigating as much risk as possible. So that is not currently available, but it will be coming in the next 2 to 3 weeks. Wanted to mention that we also have a sort of a portfolio of services that support households who are experiencing or at imminent risk of becoming homeless. And so we've got CARES Act funding to provide rapid rehousing if a household becomes homeless or it needs to have an immediate alternate housing placement. It includes housing stability case management services, all the way the spectrum of homeless to housed. And so we've got programs in the community that serve folks who are literally experiencing homelessness as well. So I wanted to mention that. And then last and not least, there was some comments about foreclosure mitigation. We do have a program, an active program that provides up to 6 months of emergency assistance for mortgage, for homeowners with mortgages. And that program also provides utility assistance, as well as support from legal aid services. So we sort of cover homeowners and renters. And while this conversation is more about eviction and renters, I just wanted to mention that. And I'm happy to answer any questions that you may have.
I am seeing one question. Is Housewake expected to continue past the end of the CDC eviction moratorium?
Yes, it is. There are 2 rounds of emergency rental assistance, the first of which must be committed by September 2022. We received an additional round, both the city and county, and I'm speaking for the county because I'm going to assume, I'm not sure if they are represented on today's panel, but that funding expires in 2025. So we've got funding and we've got a pretty long duration to provide that assistance to the community.
Okay.
So it will not stop with the expiration of a moratorium. Yes.
And so this next question is for all of the panelists, anyone who might know a source for this information. Excuse me. But is there a list of Wake County landlords that are willing to accept third-party assistance? Is there any such list that any of you know of? Because of course, knowing which landlords are willing to accept such assistance might make it easier for a person to know where to apply or where to spend their limited funds for application fees if they know who's likely to work with them on that.
I'm happy to speak to that. There has been a housing navigation unit, and I'm speaking about Wake County, and it up until the end of up until June 30th, it was operated by the Raleigh Wake Partnership to End Homelessness. Since that time, that service will be transitioned to Wake County Housing. And they're going to stand up a full-scale housing navigation unit that's going to identify landlords that will rent to households that have troubled rental history. So you're going to see that coming online pretty soon. I believe that item is going to the Board of County Commissioners to stand it up in the next week or so. But more specifically to your question, we have seen a number of landlords who have, for whatever reasons, refused to provide the documentation required to document a tenant's back due rent. And we, again, are working with the program flexibilities to sort of ameliorate that. And so right now, we're not there yet. I don't think a list of landlords actually exists that actually accept rental assistance, because we're talking about people who are currently housed. And while some of those tenants may be looking for other housing opportunities, they are stably housed at this point. And so key to the program is that the household is stably housed, and that's the emergency rental assistance program. So it doesn't really serve homeless persons, although it could provide relocation assistance if at or below 50% area median income. And we do have programs that serve specifically households that meet one of the 4 HUD definitions of homelessness, which would not include necessarily this group.
So are any of these resources available to assist families who are losing their home because the property has been sold?
That's a good question. And in the Raleigh market, that is actually happening right now. I don't know if any of you saw the news coverage of 1107 Garner Road. There is unfortunately no federal funding that really supports households that are being displaced. We call them mass evictions, and perhaps that's not the best term, but it's a better term, I think, to say displacement. 1107 Garner Road was actually, the owner sold it to another a corporation, and there was immediately a notice to evict 30 days given to all of the tenants, which it was 32 units. What we are able to do is we are able to work with our partners, our nonprofit partners in the community to serve those tenants. Passage Homes is one of our most supportive partners, while we have many, but specifically to 1107 Garner Road situation, Passage Homes has actually been able to place all of the tenants there. And we also have available affordable units that the city of Raleigh has provided financing for. And so there are some affordable units online, and we have ways to direct residents to those properties.
Okay.
So we do have tenants, landlords that will support our affordable housing needs in the city, as well as the county.
Okay. And as for the Housewake process, does the tenant have to start that, or can the landlord start that?
Our program leans more towards the tenant initiating the process. The application process, and of course the landlord can apply or express interest on behalf of the tenant. We've not seen a lot of that. Actually, I don't think I've heard of any of that happening in this market. But the tenant can apply and provide all of the necessary documentation. I don't think the flyer necessarily speaks to what that is, but yes, it does lean towards the tenant.
Okay.
Wake County's program.
And are there resources available to assist with storage units to prevent families from not only losing their home, but also their personal belongings, furniture, and major items like that?
Okay, so emergency rental assistance provides only utility and rental assistance. And there is an other category, but it's very specific. It would not cover storage units. However, our homelessness assistance programs, if the household meets one of the 4 definitions of homelessness, there are programs available to assist with that.
Okay.
In terms of housing stability, case management, as well as direct financial assistance. So, I want to make sure that the population that's literally homeless or at imminent risk of becoming homeless is a whole different sort of set of programs and program guidelines. The ERAP program only provides utility and rental assistance. And it does not provide housing stability case management services, just direct assistance in the form of those 2 elements.
Okay. So let's see what else we have. Um, so I'm not seeing any more questions right now about resource or financial assistance. So I'm going to turn back to advocacy. Actually, no, sorry, I do see a question here. This one I'll field to Jesse. So how did Durham start their eviction diversion program?
Sure. So in 2017, we started looking at evictions as a whole once we noted that Durham County was actually leading the state of North Carolina in the rate of evictions. So we wanted to know kind of what was going on with evictions in Durham County and how could we help. What we also heard at that time was the person who was running the Durham County Department of Social Services had told us about rental assistance funds that were going untapped. So they had funds, they had just expanded their staff, they had people who would be available to kind of do some of those case management needs. And for some reason, we thought it was just a matter of the community not getting the information. We also knew that there were a lot of people in the community who were dealing with a number of habitability concerns, also landlords who were violating some unfair and deceptive trade practices, or I should say who were engaged in unfair and deceptive trade practices. And so what we thought was if all three of our houses, Legal Aid, Duke Civil Justice Clinic, and Durham County Department of Social Services came together, we could have sort of a one-stop stream of people first trying to see if they qualify for rental assistance. Number two, to see if they needed legal advice to get at least a legal review of their case, either through Legal Aid of North Carolina if they qualify, or the Duke Civil Justice Clinic if they don't qualify for legal aid. The benefit from us having this program in operation since 2017 is that unlike a lot of different counties across the state, when COVID came in, we already kind of had a playbook of where to send people to, what to do, and how to save as many people from being evicted as possible. All of this stuff is kind of the offshoot of a national push for a right to counsel for all tenants in summary ejectment cases. Durham County has not embraced that yet. And so we are still trying to show that with attorneys being involved in representing the tenants in these matters, we're able to resolve a lot more cases. I believe our latest numbers were about 78% of the cases that we handle, we're able to avoid eviction judgments. And of those 78%, in 69% of the cases, we're able to avoid a move out. So those numbers are pretty good in showing that having an attorney involved kind of equalizes the playing field. In addition to that, we also are trained, and we train our students to identify issues, because when people owe money, they tend to overlook things like pest control issues, things like structural integrity, mold, all the things that would contribute to an inhabitable household. So the legal review is important because it empowers the tenant to understand what's going on in the unit, how they can legally navigate communications with the landlord, and if worst case scenario, we are empowered to be able to bring legal action if the landlord refuses to address those issues.
Okay. And we're seeing some advocacy questions here. So I'm going to kick this to Nick. Actually, two questions that you can answer back to back. How can a resident council be organized in a housing area? Although I don't know if a resident council is a specific sort of legal organization and whether that's within the realm of what you do. But if it's not, just feel free to say so. And the second question is, Nick, are you willing and able to provide organizing and training with community groups?
Thanks so much. So the answer to the first question is a little bit complicated, not to echo the lawyers and say it depends. Organizing a residence council or a tenant association is really often involved, complicated, I think beautiful and quite fun, but also difficult process that takes many steps. I think that it's hard for me to be able to sum up very quickly. How would you do that? Hopefully the answer to my second question is helpful, which is yes, absolutely. I will sit with people who want to do organizing and walk through them and help them make campaign plans and training and all of that. I'm happy to put my email in the chat. I would encourage whoever asked the question about organizing residence council to reach out to me, and whoever else is interested in talking about tenant organizing. I would love to find time to sit down with you. We can have a one-on-one talk through the particulars of your building or set of buildings. What are you thinking? What are some of the core issues you want to work on? And we'll do that. The very short version is the most important thing to do as you're trying to organize is talk to your neighbors and listen to them about what they care about, right? Often I think we try to organize something, we're like, hey, we're doing this thing. And often most important can be first going to them and say like, hey, here's what's going on in my apartment. What's going on with you? What are the things that you care about the most? And if they feel heard and valued, that's why people join organizations. Yeah, and then also I will post in the chat, but we just had in the Q&A some specifics around an organization in Raleigh, the Wake County Housing Justice Coalition. So I'll post in chat around, they're gonna be having a meeting, and so if folks are interested in looking with them, then you should do that.
Okay. Getting to the end here, are any of the resources that are offered, are any of them available for receiving mental health services? Obviously, facing eviction and possible homelessness is one of the most stressful things a person can face. So are there any resources available for mental health services, any funding assistance? Okay.
Not that I'm aware of in particular, but I do know that in Wake County, service providers are linked and familiar with each other. And so that if you are contacting one of these agencies for assistance with your rent or utility payments, ask about that, referrals that can be made to low cost service providers or assistance that could be available for that, because there are providers in Wake County who offer those services to folks. And so 211 may also have some direction for folks, because that is not just a statewide referral source for housing related issues, but a variety of resources that are available for folks all across the state. So check there and check in with your local, service providers as well whenever you are applying for the rent assistance programs that we're talking about.
Okay. One last legal question. If I'm going to kick this to Jesse, if you can answer it in a minute or less, please. What could a tenant do if they're concerned that the landlord might receive the assistance, the landlord gets paid, but then their lease is just not renewed? What could a tenant do to try to protect against that?
So the way that most of these rental assistance programs are operating is there's going to be about a 60-day, and that's roughly just depending on the HOPE program and some of our ERAP programs. There's a 60-day non-evict period. So even if you are on a month-to-month and you get the rental assistance funds, for 60 days at least, you'll be able to stay put. But other than that, there's not much. And of course, when people aren't in an active lease, you normally would have a lesser degree of protection anyway.
Okay. All right, so we're approaching the end here. So I'm going to ask all of our panelists to one more time, provide, since we don't have chat, everyone get your pens and papers ready. Everyone, if you could provide your own or your organization's contact information. And so I'm going to go in the order that I see you on my screen. So Jesse, Nick, Sarah, and Lamont.
The best way to reach out to the Duke Civil Justice Clinic is through me, and I would say via email. So I have a record that you tried to reach out. My email address is McCoy, MCCOY, at law, LAW, .duke, DUKE, .edu. So McCoy at law.duke.edu. My phone number, even though I know I'm hard to reach, it's 919-613-6936. If you call, please leave a voicemail message, because otherwise it will be nearly impossible to get back with you.
All right, Nick.
Great. I tried to put my email in the chat, so hopefully that is there, but my email is nmacleod, like my last name, NMACLEOD @nchousing.org. And that is the best way to reach out to me. Yeah, thanks so much.
Sarah?
For legal aid, you'll want to visit our website at legalaidnc.org. That's legalaidnc.org. And our helpline is 866-219-5262.
And Lamont. Well, we already saw that that website, the Housewake website, that is, and so we can all Google for that again. And so at this time that we're coming to the end, so I'm actually going to turn it over to the chair of the Fair Housing Hearing Board, Sandra Collins.
I had to start the video and unmute. Oh my God, how awesome, how awesome. I am Sandra Collins, and I am the chair of the Raleigh Fair Housing Hearing Board. And where do we go from here? I would just like to say, on behalf of the Raleigh Fair Housing Hearing Board and Legal Aid of North Carolina, thank you so much to our awesome panelists and our facilitator, Tolu. Tolu is the newest member of the Raleigh Fair Housing Hearing Board. I don't even think he's been around a month. He's jumped in, and I don't even know if he knows what he signed up for, but he seems to have passion, and that's definitely what it requires to do what we do. So again, thank each and every one of you. To our audience, thank you for chiming in and asking questions, and hopefully the panelists were able to address your questions and concerns. We've learned so much. I know I've learned a lot regarding the CDC eviction declaration process, the court process, rental and homeowners foreclosure assistance, legal programs, and most importantly, your rights. You know, we forget that we have rights. And we hope that everything that was shared tonight will help you or someone you know in a positive manner. Just for the record, a list of resources and this recording will be available for you on the Fair Housing Hearing Board website. Please share it with your residents, that people and your friends and your neighbors that may be affected by the expiration of the CDC's eviction moratorium. And finally, I'm excited to say that this is the first of 3 series. We're planning a session in the months of September and October. And earlier there was a question regarding home ownership. So we do plan to have a session around home ownership, because we know that some of the challenges aren't just for renters, but for homeowners. So And anyone that's still on the line, if there's anything you would like for us to address, reach out to the Raleigh Fair Housing Hearing Board or Legal Aid of North Carolina. Again, I thank every one of you for your time. It is appreciated. I'm sure the audience and the learners appreciate it. And thank you, and good night.